Can my employer change my job title without consent? Imagine this. You walk into work on Monday and discover your job title has changed. Maybe you were assistant manager last week, but today you're suddenly listed as shift supervisor. No one asked for your approval and you're left wondering, can my employer legally change my job title without my consent? It's a common concern, especially in industries like retail, healthcare, or corporate offices where job titles can shift often. Titles matter for pay, benefits, promotions, and even future job applications. Employers sometimes downplay it, calling it just a label, but workers know it can affect careers in real ways. In this video, we'll break it down clearly. We'll explain what the law says about job titles, when a change is legal, when it might be unlawful or discriminatory, how it connects to wage and hour laws, and what workers can do if a title change feels unfair. The basics: at-will employment and job titles. In the U.S., most workers are employed under at-will employment. This means employers can make many changes, including schedules, job duties, and yes, titles, without formal consent. Unless you have an employment contract or union agreement that guarantees a specific title, employers generally can relabel positions. But at will is not unlimited power. Employers cannot change job titles for illegal reasons, such as discrimination or retaliation. And if the new title affects pay, classification, or benefits, other federal laws may come into play. Example: an employer renames a receptionist as front desk coordinator. If pay and duties remain the same, it's typically legal, but if the title change is used to avoid paying overtime or benefits, that could violate wage and hour laws. Wage and hour laws, the role of the FLSA. The Fair Labor Standards Act, FLSA, doesn't regulate job titles, it regulates pay. But employers sometimes manipulate titles to dodge requirements. Exempt versus non-exempt. Employers may give inflated titles like manager to claim a worker is exempt from overtime. But the law looks at job duties, not titles. If the actual tasks don't meet exemption criteria, the worker must still get overtime. Minimum wage. Regardless of title, workers must earn at least minimum wage. Record keeping. Employers must track hours worked, even if titles suggest salaried or exempt roles. Example: a restaurant changes server to assistant manager to avoid overtime. If the worker still serves tables and doesn't supervise staff, they remain non-exempt and must be paid overtime under the FLSA discrimination and retaliation concerns. Changing a job title may be illegal if motivated by discrimination or retaliation. Title VII of the Civil Rights Act protects workers against discrimination based on race, sex, religion, or national origin. The Americans with Disabilities Act, A.D.E.A., prohibits title changes that strip duties after a worker requests accommodation. The Age Discrimination in Employment Act, A.D.E.A., protects older workers from being downgraded into lesser titles based on age. Retaliation laws bar employers from changing titles to punish workers who filed complaints, reported harassment, or engaged in union activity. Example: a woman complains about gender bias. Soon after, her title changes from project manager to coordinator, even though duties stay the same. That can be evidence of retaliation under Title VII. Contracts, handbooks, and union agreements. For many employees, rights depend on what's written in contracts or collective bargaining agreements. Employment contracts. If a contract promises a specific title or rank, the employer cannot change it unilaterally without breaching the agreement. Employee handbooks. While often not binding contracts, handbooks may outline probation, promotion, or title change policies. Employers may face legal risk if they ignore their own written procedures. Union contracts. Collective bargaining agreements often require employers to negotiate title changes, since titles may affect pay grades, job security, and seniority. Example: in a unionized plant, changing machine operator to technician without bargaining could violate the National Labor Relations Act, NLRA. Impact on benefits and career growth. Titles aren't just labels. They affect real outcomes. Health insurance and benefits. Some benefits are tied to job classification. If your title shift lowers classification, you could lose eligibility. Employers must follow the Affordable Care Act, ACA rules on coverage. Retirement and promotion tracks. Titles often determine eligibility for leadership pipelines or 401k matching tiers. Future job applications. A lower-sounding title can hurt career prospects when applying elsewhere. Example: an IT worker's title is changed from engineer to technician. Even if pay doesn't change, the new title may reduce promotion chances and marketability. If this change is applied selectively to certain groups, it could be evidence of discrimination. Real-world cases and enforcement courts and regulators have addressed title manipulation many times. Case 1. Retail workers labeled assistant managers sued for unpaid overtime. Courts ruled that actual duties controlled, not titles, and workers won back pay. Case 2. An older employee's title was downgraded while younger peers kept theirs. The court found age discrimination under the A.D.E.A. Case 3. A company reclassified unionized workers with new titles to weaken bargaining units. The NLRB ruled this violated the NLRA. Case 4. In healthcare, nurses given coordinator titles without duty changes filed FLSA claims for misclassification and won. These examples show that while titles can change, the law looks at reality, not labels. What workers can do if a title change happens. If your employer changes your title, here are practical steps. 1. Check your pay and duties. If nothing changes, it may just be cosmetic. If pay or overtime eligibility changes, red flags go up. 2. Review contracts and policies. Look for promises about titles or classification. 3. Document everything. Save notices, emails, and pay stubs showing changes. 4. Watch for retaliation. If the timing follows a complaint or protected activity, it may be illegal. 5. Ask HR for clarification. Sometimes title changes are part of restructuring, but transparency matters. 6. Seek legal advice. If you suspect discrimination or wage law violations, talk to a labor attorney or file with the Department of Labor. Example: a call center worker's title changes right after she joins a union effort. She documents the timing and files a retaliation claim with the NLRB, the bigger picture. In most cases, employers can change titles without asking for consent, but workers are not powerless. The law prevents misuse of title changes to dodge overtime, discriminate, or retaliate. The substance of the job, what you do, how you're paid, and whether you're treated fairly matters more than the label on paper. For workers, the key is to look beyond the name. If your duties, pay, and rights stay intact, the change may be harmless. But if the title shift hides illegal treatment, the law offers remedies. So, can your employer change your job title without consent? Generally, yes. Under at-will employment, most companies can relabel positions, but they cannot use titles to cheat workers out of pay, discriminate, or retaliate. The FLSA, Title VII, A.D.A., A.D.E.A., and the NLRA all set limits. The bottom line, titles may change, but your core rights remain. If a new title comes with lost pay, fewer benefits, or feels like punishment, The law may be on your side. If this video helped clarify your rights, share it with coworkers. The more workers understand about job classifications, the easier it is to stand up for fairness in the workplace.